Why don't we begin? It's a pleasure and an honor for me to welcome you to this second in a series of international law conversations between scholars at the Fletcher School and scholars at ITAM. And this one will be between my colleague Tom Dannenbaum, working with former dean, now Professor Jorge Cerdio of ITAM. And their topic is human rights in the era of international law. I think that title was probably chosen to frighten us with images of science fiction movies like The Terminator or The Matrix, and to put us in mind of Isaac Asimov's classic 3 Laws of Robotics. I don't know if we'll get to those issues, but I start to wonder about those. So I'm Joel Trachtman. I'm the director of the LLM program at Fletcher. I'm now going to turn the proceedings over to my colleague, Tom Dannenbaum. Tom?
Thanks very much, Joel. Well, I'm delighted to participate in this international law conversation on the issue of human rights in the era of artificial intelligence with Professor Jorge Cerdio of ITAM. Artificial intelligence implicates human rights in multi-layered and complex ways. It both holds great promise for certain human rights, perhaps most notably in the area of healthcare, but also at the same time, and even in those same domains, holds significant threats for human rights. Both threats that are really amplifications or exacerbations of long-standing human rights issues, such as discrimination, or issues relating to mental or bodily integrity or privacy, challenges around transboundary harm, but also qualitatively distinctive kinds of concern that implicate human rights but in new and different ways. Concerns around issues to do with explainability and transparency that go to the very capability of individuals to recognize when their rights are being violated and to challenge those violations, and also raise questions around the nature of our moral claim to justifiability with respect to certain kinds of harms imposed on us, and our moral claim to reasons when those harms are inflicted upon us. It also raises questions related to the issue of human control and the related concerns around accountability and responsibility and traceability. And it goes to some of the very premises of our capacity for self-government and democracy around electoral processes, but also electoral campaigns and the like, potentially implicating a range of human rights, but perhaps in ways that aren't necessarily straightforwardly addressed through our traditional human rights mechanisms. And that's before we even get into the longer term, further along the horizon concerns relating to mass unemployment or human enfeeblement or technological singularity. And layered on top of these substantive concerns are concerns around process and institutions. Are the processes and institutions that we have in the context of human rights law sufficient to address these kinds of challenges, whether those are amplifications of pre-existing challenges or whether they are distinctive and new challenges, and whether human rights is in fact the right normative framework through which to analyze these issues in the first place. So those are the kinds of issues that we're going to be discussing. And to help us think through those questions, I'm delighted and privileged to introduce Professor Jorge Cerdio. Professor Cerdio is a full professor at ITAM Law School, where he was the dean from 2009 to 2020. He works on issues to do with legal argumentation, law and logic, legal theory, and law and artificial intelligence. At ITAM, he's the head of the Center for Access to Justice, a center that provides legal aid and counsel to underprivileged persons and promotes social awareness among the legal community through an extensive clinical education program. And most notably, from our point of view in this discussion, he's in charge of the research program on artificial intelligence and human rights and open data initiatives. And he is a member of the policy development group that has elaborated the feasibility study for the regulation on artificial intelligence and human rights for the ad hoc committee on artificial intelligence under the Council of Europe, with whom I understand he was speaking at 2 a.m. this morning due to the time difference. So we are delighted that he's still going. Professor Cerdio holds an LLB degree from ITAM and a PhD from the University of Buenos Aires in Argentina. That's in law. And the way we'll structure the conversation is Professor Cerdio will give us a brief overview of the key issues as he understands them. He and I will then engage in a conversation during which you're invited to pose questions in the chat, and I'll then start to select from those questions and pose them in the conversation. So, Professor, as I said, it's a great privilege to have you with us and my honor to introduce you. And the floor is now yours. And I was thinking that it might be useful for the audience if you could start us with what your understanding of artificial intelligence really is, since there's a diversity of definitions out there, and it might help to frame the discussion to know what we're really discussing here and therefore have a little bit more of a concrete sense of what the implications of it are. Thank you very much for joining us.
Thank you, Tom. Thank you, Joel, for the presentation. It's a pleasure for me to be here in these international conversations. I have the privilege to speak about a topic that I find passionate about, and I believe that there's enough going on this subject for us to organize a more broad conversation. So I'll celebrate these type of events, and so thank you so much for hosting me. Yeah, I think about the idea of AI, we should distinguish between the discipline of AI. Artificial intelligence is a discipline in itself which intercross many other disciplines, from data to robotics to computer science. So artificial intelligence as a discipline involves the study of how intelligence, which is a bit problematic in terms of definition, can be replicated and can be reproduced on artificial systems. But in a more concrete sense, leaving aside the idea of the discipline, which could involve different research paths, we can speak about systems that can, as of now, because this is quite evolving, show certain properties. Systems that can, first of all, interact with their environment, adapt to various responses from different inputs, and produce an interaction that could be ascribed as intelligent or with certain degree of autonomy. Examples of these type of properties, we can see it, for example, in systems where you have the task of recognizing a certain pattern. Say you are trying to avoid a certain type of terrain because you want to start building a construction that requires a very specific type of grounding of soil. So you could have an algorithm, a system that could recognize different traces of the soil. These could be in dynamic terms, and then it could take the decision where it could be best to start building this construction. This could be one of the exact cases of these properties, because you have inputs, outputs, you have environment that is changing, that is uncertain, and then you have an internal model that adapts to that environment and takes decisions in an autonomous way, in a certain autonomous way. On the other hand, you could have less autonomous system that also exhibit these type of properties. For example, when a doctor is assisted in detecting or diagnosing a rare disease, where he has different inputs from different symptoms and lab testing and different markers, and yet the margin of appreciation could be vast if you have rare diseases. So you could be assisted by an agent that could process all the chances of bringing together in a matricial way all these rare flags from the clinical perspective into assisting the decision of whether the diagnosis should be one X or Y rare disease. These also exhibit the same properties I mentioned, but with a lesser degrees of autonomy, because the last decision will be taken by the physician. So I would say that it's useful to think of AI systems instead of just speaking of AI. And just for everyone to grasp perhaps a useful comparison, if we could recall, some of us who are old enough, how the cellular phones look like, the mobile phones look like in the 1990s, they perform, I would say, quite well for the purpose of communicating. They were bulky. They ran out of battery quite soon. Didn't have that much autonomy. I would say that AI systems look like our phones, our mobile phones look like in the 1990s. There's still a long way to go. That's why any definition needs to take care of the state of the art. As of now, I think these are the main properties for studying a sensible conversation on the subject. If I may then proceed to say that once we have this in mind, then it's not science fiction, the things that we are interested on, even if Isaac Asimov is quite interesting by itself philosophically, but the effects that we are now seeing. And let me just clear out that I'm not saying that AI systems are not beneficial. I think they are quite beneficial in many different areas, and they are changing the way we perform certain tasks. They're quite useful as a tool. But they have already producing certain effects, or we can see how they are producing certain effects. Let me give you one example. If we think of justice and fairness and the right to a fair trial, one of the key cornerstones of that right is the right to challenge the allegations. So when you're facing an accusation, you can defend yourself because you can hear the accusation, and then you can hear the evidential base under which the accusation is grounded. But when someone is facing an AI system that aids the judge in assessing the potential, the criminality of an accused in terms of recidivism, where the system is constructed by the architecture of neural networks that are not transparent in the sense that they cannot explain away specifically or backtracing the specific reasoning of why they are allocating a higher risk of escape or prone to violence for a specific defendant or not the other, then I'm left without that right. I cannot challenge what the system is producing to the judge, and plus, the judge could be somehow mesmerized by the idea that this is objective because it's produced by a system. And we have seen, and there's some research that have detected that some of the information that is being built into the training sets for those systems could be biased. For example, and selecting out certain defendants from racial origin, in particularly African Americans in the US, for example. Or to say this, when you use a system in terms of law enforcement, you have the right to at least be given the chance of have a say in terms of how you want the police to perceive yourself as a citizen, and you want the police not to judge you or discriminate you by the appearances that you have, or have you wear clothes or a burqa, or whether your skin is color or not. Yet, if you have police and enforcements, task force enforcements that are using a system that yields chances of certain individuals biometrically detected to be involved with a tendency to commit crimes, then you are producing a bias in terms of the perception the police enforcers have upon you. And so you're not longer aiming at the ideal of that unless you do something because of your actions, not your looks or your gender or your race, law enforcement has to remain neutral. Then the systems could produce a greater social bias. Then again, this could be a really vicious cycle. If they collected data from past information on crime that are data that, of course, includes certain structural inequalities from that community, then the system will select out the same groups target on those inequalities because they have more chances in the past just because of how they structured information and they feed eventually the system. There's a case about this. Now moving towards how some some states are using AI agents to allocate rights. In this case, immigration and social rights. You have massive amount of applications for social rights and employment benefits, and it could be very useful to have an AI system just to analyze all the applications and to select out the ones that are most likely to be beneficial and prioritize them, prioritize all the applications. So in this case, you also want to detect fraud. That is when someone is applying to a benefit, but it's not really needing the benefit. So it was the case that is now held under scrutiny under a court in the Netherlands, where they use a system to detect and to single out potential frauds in the unemployment and social benefit system. But the complaint from NGOs is that the individuals that were selected out for an investigation, for an inquiry, were consistently from certain parts of the city where immigrants usually reside, and with certain racial origin, and not from other different neighborhoods where typically they were white, they were from the Netherlands originally. And they were alleging that the system internalized a bias on it. And this is not merely the case of discrimination, but the case of where if we are using an AI agent to allocate rights, social rights, then it's not merely a case of discrimination by the profiling, but by the allocation of certain rights. And the same can happen to health rights, university access, higher education access, and so much and so forth. And then, of course, you have what you mentioned, Tom, certain more subtle or nuanced effects that yields instability in certain institutions. If we think about how healthy a democracy is just because of public debate and the circulation of ideas, well, if we have curators of information feeding certain groups specific information and censoring other information, then you replicate the division, the social division, and you hinder the circulation of ideas. The chances that I find myself finding an idea, a platform, a political speech, or even a document that does not correspond to my profile under those agents' system parameters are really scarce. They tend to be zero. So this means that the more we rely on these systems to curate and to procure the information that we as citizens use and consume, the less our societies at large will be robust in terms of a plurality of ideas and I would say the core of any democracy, which is that the circulation of many ideas or many viewpoints make us stronger when we debate them in the public arena. The idea of public reason comes alongside with this very, very idea. And last but not least, there are other examples. And one which is, I think, on the focus of many NGOs nowadays, is the effect that certain AI agent systems are having on the lives of certain strata of individuals that because of their preparation and lower education, they can only access part-time jobs. And there you find AI systems calculating and optimizing the hours and the times that they should present for specific shifts. And because they rely on a large offer of labor force for that, then they lack the basic certainty. They don't have even the idea of whether tomorrow they will have 2 or 3 hours to work on, or whether the next shift would be within 3 days or so. But behind that, there's a heavy optimization between the supply chain, the manufacturing or the service provided or produced, and the supply and demand of the consumers. So this is optimizes in a way that the labor force gets, the variable of the labor force gets maximized, but at a very high cost of a very irregular productive life. And you can think about this in terms of the time you have to spend with your family, to raise children, there are certain plans within your life. Your autonomy is highly severe if you don't have certain certainties in terms of how your work will be predictable within the next hours, so to speak. Right? And if you drop out of the system because it's an opt-in, opt-out system, which is a civil contract based system in saying that it's not unionized, then, well, it works like Uber, so to speak. And this also is a more subtle and diverse effect than the first examples that I mentioned. And last but not least, let me mention that there's the effect on using biometrics largely, and the technology behind biometrics for security and producing policies in terms of public security, which in itself is not right or wrong. There could be very good reasons to employ these methods to track down, for example, ongoing crime or human trafficking has been proved to be quite a fruitful tool to apply to. But if you set this at large as a standardized way of people to just be present in every database that this system can recognize you in a mesh format, where in every square inch of your county, city, state, it could be detected, tracked, individualized, and with a digital print that can pinpoint you at every time, every day, then the mere awareness of this mesh produces a social diffuse effect of chilling and hindering certain social rights, the exercise of social rights, of civil rights, among them to assemble. Who wants to participate in a protest if we know we're going to be praised and pinned down, but also of intimacy and privacy. I don't want for them to know every which step that I take in my life, or my children, or my wife. Where's the boundary between the public and the private? And what are the good reasons that we could have for everyone mass accumulating this information for what purposes afterwards? So let's say that, yes, cellular phones like the 1990, this is what resembles now the capabilities of AI systems, yet we see that within the current state of the art, there are good benefits of using the system, but at the same time, I think we see clear effects on different type of rights, fundamental rights. And let me add this, Tom. I think there is a consensus. So here's the challenge that you were speaking about, the institutions and regulation. I think there's a consensus that human rights are called upon playing a normative role. That there should be a human rights AI center, development, design, and deployment of systems. If you can look at different documents, the UN has a document on principles for businesses and human rights. Yeah, you have in Europe a vast amount of soft law directing this. You have private organizations like the Association for Computer Machinery or the IEEE with guidelines on how to implement ethical guided AI systems and so on. So, but behind that consensus, there's a lack of agreement as to how are we going to exactly institutionalize this. This is, in a way, a global concern. I would say there resembles much like the oceans. It's a phenomenon that goes beyond borders and beyond the different jurisdictions that we could think of. And yet, what we still don't have, it's a clear path towards the mixture of different instruments to regulate, and to what extent you want to regulate it. There's in the one end, one stream, countries like, for example, Israel, that they advocate for a light touch of regulation towards AI. They don't want to hinder innovation, and they're quite aggressive in terms of producing new initiatives on AI. And they have merely ethical guidelines, and they are aware of different concerns, but they are not willing to legislate on that. On the other extreme, you have the European Union that, although they have different interests, they do have a consensus that they want to work towards a mandatory, binding instrument, even if it is in the form of a framing convention that then every national jurisdiction can re-implement with different approaches. So you have a market for AI regulation, so to speak, and this creates a competition which is healthy in terms of which national jurisdiction within this framework can boost or hinders innovation, plus a combination with much more sectoralized soft law. We need specific regulation for aviation, for biometrics, for cybercrime, for children and youth. For gender equality is a huge issue, how you can easily have gender bias and inequalities within AI systems and so. But we don't know exactly how to approach and tackle these regulations. And then you have countries that haven't seen this as an issue at all. They function as paradises. I would say that Latin America at large is one of these examples where we know that there are investments in terms of deploying and designing systems just to be sandboxed there. So there's a consensus that human rights has to play a role. There is an agreement as to how to produce institutions or even instruments to regulate it. And I would say at last that there's a technicality which it really strikes me as conceptual, which is if we look at other ways which we have implemented human rights assessment, the Danish Human Rights Institute has a methodology on that, or environmental impact assessment, even data protection assessment from the 108 plus European Convention on Data Protection. These are easier domains to which we can think about human rights impact, because somehow we can have a more concrete prediction or view about who would the stakeholders be. So we can include them in the consultation process. We can relate to the effects. So if a business wants to implement a factory where they will hire mostly women, then we can think about some of the decisions that could be in favor of human rights and labor rights within the factory. The business has to be aware of that, and we can think about. But AI applications are contextual. They're shifting in terms of what could be wrong with a given AI application or system. Let me give you an example. We love chatbots nowadays. We love the idea that they can ease up the communication with clients. Enterprises use them to facilitate call centers, and within the evolution of AI, this is the future of large enterprises and services worldwide. Yet again, how can we imagine whether a sophisticated enough conversational AI agent would impact human rights? If taking out of that context, we could have, for example, human rights impersonating individuals. The example of Google Duplex, which is a useful application that demonstrated that once you give a voice command, the AI agent can make an appointment for you as if it were a human assistant, is an example of a technology that could, if you shift the context, could affect human rights, for example, impersonating individuals and violating their individuality, their privacy. So the thing is, how can we go about thinking about human rights in a way that are contextually relevant or not? And so you really pinpoint that question right, which is the notion of right, of human rights, enough for regulating AI systems? Or do we need to rethink or supplement in different ways? One way is to create specific rights that we have not defined yet. Specific digital rights, human-related rights for AI users and consumers and operators, or to complement the human rights approach with other approaches, more traditional in compliance-like approaches, which is still a big question. So I guess this is the cartography I had in mind. I don't know if I left out some of the points that you brilliantly put it in your presentation.
That's very helpful, Jorge. I wonder if you could sort of identify where you think the most urgent or pressing imperatives are, because you laid out a range of different kinds of challenges, both substantive challenges when you're talking about discrimination or the issue of criminal justice or labor law and the right to leisure and right to autonomy, and the chilling effect of mass surveillance on both personal life and public life, and then some of these institutional challenges. Do you see the most urgent or pressing imperative for states or other stakeholders to be to better develop the substantive rights, to codify more the way you were just suggesting? Or is it really about developing new institutions that take the existing rights we have but reconceptualize them, interpret them and apply them in new ways? Or is it about the process? And so it's not necessarily that a new institution needs to be created, but we need to think about the process of how we evaluate human rights differently, whether it's more this ex ante and continuing model as opposed to an ex post case and controversy model, and do we need all of those things at the same time, or is there one that we really need to focus our attentions on, and if so, why? And one additional question here, I guess, is one of the challenges it strikes me in this space is, and this is something I encounter when we're looking at similar issues in the law of armed conflict, which is my specialty, is the challenge of finding people who are expert across all of the different intersecting domains, the technology, the law, the lived experience of those who are affected by the technology in certain contexts, and the difficulty of bringing all of those expertises together in a way that's responsive to all of the different concerns and responsive to the realities of the technology, the capabilities of the technology, the viability of certain legal approaches, and the impacts on persons in their daily lives, and how we overcome that in this particular context. And that may feed into the prior question insofar as it maybe suggests certain challenges around institutionalization or process, and how those different lenses through which to evaluate the problem might be pursued. And we're already starting to get some questions in the chat as well. So if people have questions, keep adding those in and I'll start to bring those up as well.
I have the idea that for some of the cases that I provided, we have robust enough normative instruments to tackle that. Freedom of opinion, freedom of speech, privacy, data protection. I think we are safe in saying that we have ample enough language there to extend it to AI systems. There, the challenge is to meet the technical, I would say, expectations of designers and developers, that they are aware of the problem and they're producing their own ethical guides from the industry because they want to move the discussion towards the notion of compliance, which is, if I took care of designing a system within the ethical guidelines provided by my professional affiliation, for example, the IEEE, or if there's a private certificate for that, which is it's about to be born within the next years, then the producer of the system is not longer liable to the effects of the system. So this is one of the forces pushing forward in terms of, let's not get too excited about human rights or rights in general, because this is a technical issue at the end of the day. So if you want engineers to understand how to impact assess the system, you have to translate that into standards, into engineering standards, and this is the realm of compliance. And this is sort of the slippery slope argument then you could say that liability for and redress mechanisms should be very much like compliance redress in other fields, for example, criminal compliance for corporations. But of course, we don't want in the future to see, for example, the Department of Justice of the Ministry of Justice working with companies where they come forward and say, well, yeah, I messed up. I have a system that now produces chilling effects across the globe. Let's work together into how can I compensate or somehow redress that when we know that these type of effects, they would not go away the same way an oil leakage could go away, right? So I believe that in the one hand, to answer the question, we have enough normative robust instruments to tackle some of the main examples, but we need to think whether we need to have different rights, or I would say concept-like rights that could guarantee claims, that could provide immunities, that could be binding and require actions and produce consequences, that is rights-like conceptualizations on the digital realm and the AI system realm. So these technical expectancies and the movements can be met at some point, and saying, well, of course it's not dignity, but if you produce an AI system, you can be subject to a moratorium, where if we seek within our overseeing power of the state that you are producing certain effects, or a citizen claims that you are affecting certain rights, then you could see your system suspended effectively. And this this connects me to another question, which the second point that you were bringing about institutions and experts, right? Of course, we would need the resources of the state. Whether to create a body of people overseeing AI within a specific jurisdiction, but also cooperating internationally, sharing experiences and observations and records across different systems. AI systems, when they are valuable enough, they cross jurisdictions. There was one idea that was dropped out at some point in the PTG, the High, which was the idea of creating an European benchmark institute, where precisely lowering the cost of gathering different experts, the benchmark institute could be open to anyone who wants to sandbox a potential AI system that could bring different researchers from around the world to set out the technicalities of how to build and procure data and training, and then other civil society observers to have a more cross-intersectional approach in terms of what could be the potential effects of an AI system. But then again, what I learned from discarding this idea was that we do need a public entity of some sort, a consortium. We cannot left this out to the current institutions. This is something that I think is not becoming the consensus yet. We don't know what could the actual properties be. Then you have another difference of opinion, whether this is only registry, an AI registry just for informative purposes for citizens to know that there's an AI system in place in their city, in different public services or private services, an overseeing body that brings together engineers and academia and ethicists and other regulators, whether you could have consortiums of an international organism that oversees this. The OECD is now working in two very valuable initiatives. One is an observatory of policies across the globe, across at least the countries of OECD. And the other is a methodology to classify systems in terms of their impact. So perhaps we need a body to not merely observe, oversee, but to propose directions into policy. And then there's the idea of a benchmark institute that creates standards and certifies systems. Another consensus that I do believe is gathering is that if civil society is not empowered enough within these conversations, we will fail epically in terms of regulating AI. It's still a distal topic for the layman. We still don't see people grasping the idea of what does it mean to have an AI system have a say in terms of my information or my healthcare or my biometrics. And along with that lines, I think we need to stop being fantasizing about the black box effect of AI and start speaking about how can we translate the behavior of the system into terms that every which common citizens can understand in terms of functionalities and consequences. And this is something that is within our reach because it has nothing to do with experts on AI. It has to do with labeling, like we label products from the pharmaceutical sector or food. That is, we have examples from other domains where things could be quite complex. Think about the pharmaceutical sector, right? And yet they are obliged to produce a label that is informative enough for exactly what I need to know about the consumption of that product. So I think we should look at these discussions and not get stuck in terms of where can we find these human interfaces that will explain away and function properly within everyone's reach. So just to recap, I do believe that we have a robust normative framework for some case scenarios. For others, but specifically because of the movement towards translating these AI issues, not tackling as a human rights issue, but as a certification issue, that we need to rethink some categories for the digital and the artificial intelligence domain. This requires intervention of the state because of the massive resources we would need to create, but there isn't a consensus about what would that institution look like and what would be their capabilities concretely. And last but not least, we need the public at large. We need the citizens. We need everyone to be more aware, and then this means a wider labeling and translating effect on this topic.
Great, thank you. And so on the issue of labeling and translating and so on, that certainly can get around certain challenges where you can say, well, there's informed and free and uncoerced consent here because there's sufficient clarity about exactly what the nature of the thing with which one is interacting is. A couple of questions that have come up in the chat go to questions that I think are really around balancing and competing interests and how we make those kinds of decisions, whether it's security at the border and the use of artificial intelligence at the border, artificial intelligence in our smartphones and questions of privacy. And of course, human rights has always had to deal with this challenge of competing interests, whether it's competing rights on two sides or whether it's a core public interest such as security and human rights on the other side, and has the mechanism of proportionality to deal with that. Does the particular nature of artificial intelligence and maybe challenges around how it's going to be used in the long term, changing use, changing nature of the intelligence over time, some of the questions that may come up in particular when we're talking about big data that will maybe even shift how we start to think about these kinds of trade-offs, does that challenge the viability of proportionality as a tool for addressing these kinds of concerns about trade-offs? And if so, is there an alternative, or is there a way of taking the kinds of tools that we've used in human rights traditionally and applying them equally effectively in evaluating the way that these trade-offs play out in the context of artificial intelligence? So that's I'm trying to draw on a couple of questions here and merge them a little bit from the chat, but I think underlying them is this broader concern about how we engage in trade-offs and ultimately whether the existing mechanisms that we have in international human rights law are sufficient, and proportionality, I think, would be the most
Wow,
notable.
That's a fantastic question, and I thank the audience for this question. Let me make a distinction between different domains of the idea of balancing and proportionality. Let's distinguish between the non-judiciary arena and the judiciary arena. Right? Within the non-judicial arena, I think it's sufficient for the public at large to have redress mechanisms and information mechanisms. That is, if a jurisdiction and state wants to create an AI agents to protect their borders because this is a more efficient way to procure and to secure their national values or interests, then in terms of the non-judicial arena, what we need to know is there's the type of AI agent that is working and is at play there. What's the type of capabilities that is being displayed on? What would be the effects on other uses, civilian uses, other than the ones that was placed for? Is this system going to be open system in terms that other organisms and organizations could audit the system in terms of their reliability, but also in terms of reusing the code? So these questions are questions of public policy that could detonate other check and balances mechanisms that traditionally democracy has a very good record of putting in place. Once you have these conditions, public understanding, public overseeing and accountability of the system. So of course, there is a balance in there, but I would say it's a social hyphen political balance in there, right? And would say that democracy, if you have a robust democracy with institutions that have mutual checks and balances and a robust civil society, then those conditions suffice for any government to be a check in terms of the using. Plus, I would say, and there's something quite important, I think we need to rethink the rules of public procurement for AI systems. We need to get the idea that whenever a state procures an AI system for any public use, the standards of transparency, accountability, publicity should be higher. Just because we want to oversee the system because of the unforeseeable effects that the system could have. Right? Now, within the judicial arena, I think this is the biggest challenge of all. Let me recall one case which was biometric profiling in the UK. And the court was called upon balancing whether the public security measures and the policy using this AI system was justified vis-a-vis privacy and the chilling effect of being surveilled. And they favor the public security tool, the policy behind using biometric profiling. And I think the argument was quite solid. I mean, if you review in general the argument, and if you review the way they proceed in terms of the balancing, was coherent, was reasonable, within reasonability. They didn't set anything in stone. They could revoke or rehear the case in a future case with different circumstances, etc. So they acted as any human rights constitutional lawyer would act in terms of applying our legal reasoning standards for that. Right? But because it got to be like a typical proportionality case of rights, well, what's left outside were other stakeholders, minorities that were already being signaled and profiled, other potential uses, case uses that were not put within the Docker case before the judges. And last but not least, that once the case was resolved, there wasn't a follow-up mechanisms in terms of what are the effects now, 2 years after this ruling, 4 years after the ruling. So in that regard, yes, I think we need to rethink how the judiciary could tackle these type of cases, whether if the judiciary should use the traditional proportionality approach. I know that there are strong arguments to say that this is just a matter of how you frame them. We could look at the South Africa case for water, where you have social rights adjudicated, and then this means that a traditional court within the file docket and arguments could somehow cross over the mere judiciary and oversee public policy in terms of water allocation and what the measures are being implemented and so on. So yes, I know that this is an argument. But then again, because of the contextually changing and rapidly development of the system and the effects of AI systems, I don't believe it's the same is the same case as we have with water or education or health, right? Interesting question. I think it's a brilliant question. Thank you.
Excellent. So, and I'm just struck in part of your answer where you were referring to the importance of democracy and democratic decision-making, collective decision-making when we're outside of the judicial model. And of course, one of the challenges that we spoke at right at the beginning was this challenge that artificial intelligence may itself be impeding to a certain extent the viability of democracy, or at least some of the premises for a robust democracy. And so once those two things start to come into a clash where we need to rely on democracy and robust democratic institutions to really evaluate these kinds of problems, because the judicial model is going to be limited and only going to be able to address them in certain ways. And yet those very systems and the premises of those very systems are one of the most threatened things by artificial intelligence. How do we get out of that particular knot? What's the response to that? That seems as though it's a fundamental challenge here, that the more we need to rely on our collective political capacity to solve these problems and less on technical experts or judges or something else, the more that this really seems to be a deep challenge. And of course, we're seeing democratic institutions in retreat or under pressure in multiple different policies across the world. And so it seems as though that's we're not in our strongest moment as a matter of democratic institutions to confront this fundamental challenge.
Well, I would say that would depend on your conception of democracy. If someone was radical about democracy and saying that democracy is an empty place where everything can be constructed along the lines of the democratic game, that is free elections, free speech, and then free circulation of ideas, no matter what that means, if we, within the next 60 years, if these systems become pervasive enough for everyone that for everyone to procure any piece of information then has to do through these systems, then that would be the factual definition of our institutional democracy. And perhaps my generation would look at that as a perversion of democracy and the ruin of what the quintessence of democracy is, right? That's what a theorist of democracy would say. Yet there's a more economic issue here at play, which is empowering the very few companies that run the big data around the world. That there's a natural monopoly, like the textbook's natural monopoly when you look at the cases of the railroads. If someone has laid out the railroads, then could I be a participant of that market if I don't have one single mile of road? No, you cannot enter the market because you have a natural restriction. So the same happens with big data and these predictive algorithms. Very few people has this capacity in terms of massive processing of the big data. With the Internet of Things and different commercial alliances allowing now different massive federated inputs from our cellular phones plus our lamps plus our coffee machines, then this is a power and an economical issue, which is we need to rethink this as a threat to democracy, not merely in terms of AI and information and the circulation of ideas, but in terms of how they have the power to prevent speeches, even state-oriented communication speeches, how they have enough power to make predictions and to move masses, not merely into nudges. And now with the deep fakes and the deep interventions within social networks, they could have the power to actually turn masses towards action. So for me, that is not exactly the same discussion as the answer I gave you in terms of democratic theory, right? Which is quite romantic, so to speak. I do believe that democracy is an empty place, if you agree with the democratic rules. Yet the factual conditions, the real politics behind big data is a matter of state sovereignty, and it should be a concern for modern democracy, for democratic states. I think that, right, as a matter of fact.
Yeah, and this goes to another question that came up in the chat actually, which is about the fact that so much of what we're talking about here is really occurring in the private sector, and it's private actors who are the key movers, and yet we're looking to the state and we're thinking about mobilization through the state as the starting point for how we respond, which is of course the natural way we would think about it from the perspective of policy and law. And these private entities are not just monopolistic within a particular state, but also monopolistic across states and maybe more powerful than many states in many respects. Does that affect how you think about the way we should approach regulation, or does that just go back to some of the earlier discussions you were having about, or some of the earlier comments you were making regarding these different models that we already have legally to respond? Or does the nature of this particular kind of private actor pose a distinctive challenge that requires something quite different from either human rights or traditional business regulation?
That's an excellent question as well. I see there's a similar phenomena that was occurring around the 1970s, 1990s with global money laundering. That is, if you look at how the big players in money laundering were acting, they were acting globally. They had enough power to buy bankers across the globe, across different weak rule of law jurisdictions. And they had a massive power in terms of moving around currencies and assets for the organized crime in different jurisdictions. So the international community responded partially with the Palermo Convention, but it wasn't until different ministers of treasury got together within the Gavi group, which is the action group of financial force that tackles and tries to produce a typology of money launderers and have even the power to declare a territory a non-cooperating territory. And when they declare that, no money can get in and out within the normal banking and financial world system. This is the type of action that I believe AI would need to be implemented in the near future. That is, perhaps we will see a global regulation which is not exactly an orthodox international law-oriented regulation, but more a collective action within states that need to get hands-on and control of these pervasive and really robust power, not merely from corporations, but from other threats. We haven't spoke about cybercrime and cyber war and cyber delinquency, but if you look at the Microsoft report on cyber attacks within the COVID pandemic, you will see the rise of the cyber attacks, because everyone now is with in front of the monitor of the computer, and the computer is running 24/7. So that presents an open opportunity to increase the attacks, right? So because of the huge amount of power and coordination that someone could have with big data plus AI systems, I don't see that we will see a regulation that is not a global regulation like we had in the 1970s, 80s with money laundering. That said, I don't see that's the road Europe is taking. I see the Europe implicitly. I mean, Europe is a different vast diversity of approaches, but I think data protection really produced a domino effect across the world. The GDPR and the 1A plus really had a domino effect across different jurisdictions, either because people wanted to get data out of Europe or transaction with Europe or do business with Europe, or indirectly just wanted to be on the safe side. And then I don't know if I'm doing business with Europe, but I want to comply with. And so I think they have that in mind. They think that if they strike a sensible enough, well-oriented, concrete regulation on AI systems, the world will follow somehow. I have my doubts about that.
That links directly to a speaker we had earlier in the year, Anu Bradford, who spoke about the Brussels effect and precisely this notion that Europe, by regulating internally because of its trade effects, can have regulatory impact more globally. We have actually run out of time remarkably, because there's still so many areas to discuss here, and it's been an extremely rich discussion. but we did say we would close at 2, and so I suppose that's what we have an obligation to do. But this was a really fantastic insight, Jorge. Thank you so much for sharing your thoughts with us. We covered a lot of terrain, and I'm sure left many provocative thoughts and questions for everybody in the audience. So thank you so much for joining us in this.
No, thank you. I thank the audience, really.
Thank you. My pleasure.